5 seconds to go. Start. That the presumption under section 20 of the Act would apply only if the fact of demand and acceptance or of illegal gratification, as the case may be, is proved. Such a proof can be adduced even by way of circumstantial evidence in the absence of direct evidence. This would be so particularly in trap cases, as the prosecution has to prove that the accused had demanded a bribe from the complainant. The factum of demand can be either proved by direct evidence or through circumstantial evidence. Shri Sushil Kumar Jain, learned senior counsel, also submitted that the demand of a valuable thing or pecuniary advantage, either for himself or for some other person, is a necessary ingredient or a sine qua non to bring home a conviction under sections 7 and 13(1)(d). The demand can be proved either by direct oral evidence or documentary evidence. That the presumption under section 20 is applicable only in respect of offences under sections 7, 11 and section 13(1)(a) and (b), since the demand is a part of the word obtained. However, this foundational fact has to be proved and cannot be presumed. So, also with regard to the word accepted, the demand must be proved. That section 20 is akin to section 4 of the 1947 Act, and prior to the Act coming into force, the offences against corrupt public servants were also covered under sections 161 and 165A of the IPC. Section 4 of the 1947 Act prescribed the statutory presumptions for offences under sections 161 and 165 of the IPC. By section 31 of the Act, sections 161 to 165A were repealed and are now covered by sections 7 and 11 of the Act. The Act is a special statute and a complete code by itself. Learned senior counsel further urged that under the criminal jurisprudence in India, there is always a presumption of innocence until the guilt is proved, and there is no presumption of guilt. Therefore, there has to be proof beyond reasonable doubt of a demand and its acceptance so as to bring home the guilt of the accused. In this regard, reliance was placed on para 18 of M. Narsingha Rao. Ms. Aishwarya Bhati, learned ASG, drew our attention to the report of the Committee on the Prevention of Corruption Act submitted by the K. Sanathanam Committee and contended that it has been stated therein that corruption has increased to a large extent and people have started losing faith in the integrity of public administration. Reliance was placed on State of Madhya Pradesh versus Ram Singh 2005 SCC 88 to draw our attention to the fact that the Act has been intended to make effective provisions for the prevention of bribery and corruption, which has been rampant amongst the public servants. The Act is a social legislation intended to curb the illegal activities of public servants. The principal fact can be proved indirectly by means of certain inferences drawn from its existence or its connection with other circumstantial evidence. It is often said that witnesses may lie but not the circumstances. However, the court must adopt a cautious approach while basing its conviction purely on circumstantial evidence. Inference of guilt can be drawn only when all incriminating facts and circumstances are found to be incompatible with the innocence of an accused. In other words, circumstantial evidence is not direct to the point in issue but consists of evidence of various other facts which are so closely associated with the fact in issue that taken together they form a chain of circumstances from which the existence of the principal fact can be legally inferred or presumed. It is trite law that in cases dependent on circumstantial evidence, the inference of guilt can be made if all the incriminating facts and circumstances are incompatible with the innocence of the accused or any other reasonable hypothesis than that of his guilt, and provide a cogent and complete chain of events which leave no reasonable doubt in the judicial mind. When an incriminating evidence is put to the accused and the said accused either offers no explanation or offers an explanation which is found to be untrue, then the same becomes an additional link in the chain of circumstances to make it complete. If the combined effect of all the proven facts taken together is conclusive in establishing the guilt of the accused, a conviction would be justified even though any one or more of those facts by itself is not decisive. In Kundan Lal versus the Custodian, Evacuee Property, Bombay AIR 1961 SC 1316, this court, speaking through K. Subbarao, judge, observed that the rules of evidence pertaining to burden of proof are embodied in Chapter 7 of the Evidence Act. The phrase burden of proof has two meanings: one, the burden of proof as a matter of law and pleading, and the other, the burden of establishing a case. The former is fixed as a question of law on the basis of the pleadings and is unchanged during the entire trial, whereas the latter is not constant but shifts as soon as a party adduces sufficient evidence to raise a presumption in this favor. Stop.